and figuring it out. So, hey, so today we're going to be talking about closings and snares and timelines, or in my little name that I like to call it, it is Termination Tango. Who here has had to terminate a contract or a buyer brokerage agreement in the past? Anybody? I would think everybody. Yes. So unless you're relatively new, you probably have at some point in time. And by the way, I'm going to just let everybody know, for those of you that have not been in my compliance chats before, I welcome you to put your videos on. You don't have to, but I sure like to see you. I like this to be interactive. So and feel free to interrupt at any point in time. This is really more, think of it more of a, thank you, Deborah. Think of it more of a mastermind, because we are all experts here. You know, Shayna has tons to offer, Delacy, Deborah, all of you, we all have something to offer. So if I say something and you have something to add, or even say, hey, you're wrong, that's okay, because we're all in this together. So this is good. I like being able to really think of it, like I said, as a mastermind, not me teaching anything. But for those of you that don't know me, I am a GREC instructor. I'm a compliance broker and associate broker at Maximum.
Right.
And I love helping others succeed. So today we're going to be talking about that termination tango that we go through, the closings and snares and timelines, because there are proper ways. In fact, right before I got on this call, I had to deal with something like this. You know, somebody was so upset that a contract was terminating, and they just felt like, why are they terminating it when we could get this closed? Unfortunately, that does happen, right? So let's go ahead and take a look at a few things here that we can do. Before I get started on that, how many of you have, let me rephrase this. What is the most difficult part of terminating a brokerage agreement? And go ahead and unmute yourselves to speak. What is the most difficult part of terminating a brokerage agreement? Anybody?
I didn't even know you had to terminate brokerage agreements. I've never had a contract terminate, but I've had people under buyer brokerage agreements that didn't buy or whatever, and I just let them, I just didn't do anything with it.
Gotcha. Well, good point. Deborah says she's had no contracts terminate. That's awesome. But buyer brokerage, she's just kind of let them go. Here's the issue. If they did go to another agent, you technically would be entitled to a commission if they were under a buyer brokerage. So you would want to terminate it. Well, the buyer should have wanted it terminated. But at that point, you know, I would go ahead and do a proper termination so that everybody is clear on it. I don't like ambiguity. That's my big thing. But let me go back here. Sorry. But there are proper ways to terminate them. We can terminate, and we can always terminate brokerage agreements, leases, purchase and sale, and contingencies. And of all those to terminate, there's really not one that's easier than the other, right? I would say that for me, hi, Carol. For me, the most difficult to terminate is a brokerage agreement, because it's got the most emotion. Well, that's not true, because when you're doing a contract, you're also going to deal with emotion, right? But it depends on what side you're on. But these are the contracts that you can, or the agreements that you can terminate. And with that, there are proper ways to do so. You can't just let it go. Like Deborah had mentioned, you just don't let it go, because properly terminated, it wouldn't have been. So we want to make sure that we're doing it the right way. So for instance, on a brokerage agreement, you always want to make sure that the brokerage agreement is, first of all, enforceable. And obviously, with what has happened in the last few days, you definitely want to have a brokerage agreement that you can terminate, right? And when are we supposed to have that buyer brokerage agreement, guys?
Prior to showing property.
Prior to showing any property. And I'm telling you guys, you got to do it more than ever now, right? I've been shoving this down y'all's throats for 2 years now, but you have to have that before you ever show a property. Because if not, you're not going to be protected. And yes, you can do a customer acknowledgement, but guess what? If you have a customer acknowledgement, there is no commission protection. So be very aware that a buyer brokerage agreement is huge right now. You have to make sure that the address and dates are correct. Anything that says TBD or TBA, all those things are not enforceable. They have to be clear and concise. That's why, and we'll talk further on that, but even things like on or before, that's not enforceable. So you have to make sure that those things are correct. You want to make sure that the signatures and the initials are complete. If something's missing, technically it could still be enforceable, but there's going to be a little bit more process to it. And of course, if you put on, for instance, the brokerage agreement that you have attached a protect your seller, what to know when you're selling a property, all those brochures, you better have them. Don't don't check anything if you're not going to have them. So make sure that whatever you check on there is attached. So those have to be in agreement. Additionally, if it's a listing agreement, a seller's agreement, you have to have that lead base if it was before 78, or if anything in the home was built before 78 at the time of listing. So if, and that's what, oh, I didn't even realize I put that on the slide, but yeah, it has to be attached before you go ahead and put that listing out. You cannot ask a buyer to put in the contract that the lead base will be given 24 or 48 hours later, like you could with, say, a seller's disclosure. The lead base has to be done at the time of listing. Now, when you terminate a brokerage agreement, it could be mutual. It could be unilateral. Anybody ever do a mutual agreement here before? I did once. And that was because I was done working with that person. And it was one of those things that I called and I said, look, we're just going to mutually terminate at this point. And the mutual termination, the biggest deal is you have no protection period. So the protection period, obviously, if I felt that they were trying to scam me or something like that, I probably would not have agreed to a mutual. But the mutual termination, the big thing is the no protection period. The unilateral, either party can terminate and that protection period stays in place. Keep in mind, if you have a listing agreement and you have, say, 90 days of protection period, and Shayna is the listing agent and she terminates it as a unilateral termination, but then I go and list that property that she terminated, that protection period's done. That's not what a protection period is. And we're not going to talk about that too much today, but I want to make sure you understand. If it's relisted, that protection period's gone. But if, for instance, Shayna terminates that contract, that buyer or seller brokerage, and then that seller goes and sells it to their neighbor, then Shayna would be owed a commission. So with that, you can do the mutual termination or you could do the unilateral. Either one will work. Now, what you don't want to ever do is if a buyer or a seller comes to you and says, hey, Deborah, can I just ask you, how do I terminate my contract with my agent? You cannot answer that question. You simply say you need to speak with your agent. Simple as that. You cannot say, oh, you just need to go fill out F-152 or F-155. No, don't do that. I actually had somebody do that. And it was pretty funny because they sent the email saying, oh, this agent, the one that wanted to get the listing, this agent told me to fill this out, or to have you fill this out and this and that. And I was like, oh, really? So there you've got a nice little code of ethics fight going on. So be careful with that. Now, if you're not a realtor or if you don't have access to the GAR forms, it would be the RE 260 that you would use in order to terminate. Because RE forms tend to be a little more generalized. They don't have a form for everything, right? Necessarily, where GAR has a form for everything. So you would use the RE 260. If client, the notice goes to the agent. Many people don't realize that if somebody tells you that they are only going to be representing the buyer or the seller as a customer, then the other party has to give notice to the customer, not to the agent. Now, would I send it to the agent as well? Most likely. just as courtesy, but you have to include the customer. So for instance, if I have a contract that Carol sent to me, I would probably look, and I see that Carol says that she's representing the seller as a customer, and I was representing the buyer, I would immediately turn to the last page of the contract and make sure that all the information of that customer is on there. Obviously, if both are clients, I'm not going to need that information. But if one of them happens to be a customer, then all of their information has to be on that last page. So make it a point of habit to look at that, because at that point, you have to give all notice to the customer. Everyone clear on that? Okay. If you have questions, stop me. Feel free to stop me. But always check for those emails and phone numbers on that last page, because that's going to be necessary if it's a customer relationship. Again, try never to work with somebody as a customer, especially now, because you're going to not be protected unless you're the listing agent and the buyer's coming to you as a customer. And they are very well aware that they're not going to have representation. And guys, I think that's going to happen a lot too. So be aware of that. So if you're terminating the seller brokerage agreement, to remove it from MLS, there is a fee, right? There's $25 FMLS and 25 GMLS. You would need the form F-116 for FMLS. Decide when they terminate who's going to pay the fees. If the seller is paying them, they have to pay the broker. Well, confirm with your office. But in theory, you should not be receiving that money. They shouldn't Venmo or Zelle you, right? So make sure you figure that out with your office, how that's being done. But always confirm prior to the termination. Let them know there's going to be a $25 fee for each MLS. And if you want it terminated, there's going to be a fee, right? With that, the addendum to FMLS, right to sell listing contract, right here is the 116 that I was referencing. You can go ahead and fill out whatever you need to fill out. You would then go ahead and put the withdrawal if you're withdrawing it, and make sure that the broker's signatures is signed. The buyer or the seller, I mean, in this case, the seller does not have to sign, only the broker, okay? So if you need to terminate and take it out of MLS, that's how you would do it. When you are doing it as a mutual agreement, that's final. It's a final agreement. You both decided, that's it, we're divorcing, right? It's a final divorce, settlement done. Quickest divorce ever. No further liability. No further obligations. But it does require the broker and client to sign that release. You're no longer responsible to each other. In that point, you would use that Form 152, but understand that there is no protection period. You're not going to get a commission later by terminating it with a mutual agreement. That applies to seller brokerage, that applies to buyer brokerage. So just be aware of what the differences are, mutual or unilateral. So this is the mutual, this is what it looks like, and pretty self-explanatory. You simply are talking that you are both agreeing, and see number 3 where it says, with the execution of this agreement, the client shall pay the broker X amount to reimburse the fees. In our listing agreements, it does say that if the seller wants to terminate a contract, a brokerage agreement, that you are entitled to actual marketing expenses. Has anyone ever gone after their seller for that if they've terminated? Okay, you can. Now, you have to be actual. Don't just say, oh, it cost me, this amount, that amount. No, be actual expenses. So you paid for a photographer, you paid for a drone photography, you paid for postcards just listed. All of that, keep track. I hope that you have some way of accounting what your financial input is for each property on each listing. That way, if for any reason something goes bad, you have that to say, here you go. Here's my financial documentation, because you can. And that would be a way, if you wanted to keep that listing, to say, okay, I'll gladly terminate, but this is what you're going to owe me. And if they don't want to pay you, you keep it active and try to sell it. Of course, that's going to be a case-by-case scenario. Sometimes you're better off just, cutting your losses and being done, right? It really depends. We are in a stage, especially with the climate of our careers and businesses right now and the changes that are happening, that you don't want, excuse my French, but BS. No BS, right? We are in a no BS. Any professional realtor or real estate agent now should be thinking no BS. We don't want to deal with a client that doesn't want to buy. If they're a buyer, we don't want to deal with a seller that doesn't want to sell. We don't want to just see our name on a sign outside, right? We want to sell that property. You are in this to actually sell or buy. So think of no BS. That's my motto for this year. So no BS. So with that, if you're going to do it unilaterally, obviously either party can terminate. It can be you as the agent, it can be them as the client, but there may be further liability. This means fine. You're telling me you're going to terminate because you don't want to have your house on the market any longer, right? Okay, that's fine. You will go ahead and terminate, but we're going to do it as a one side, only one side, because the protection period applies. You caught wind that the neighbor has been talking to your seller and saying that I want to buy the house, and let's just cut out, Deborah from the transaction. See, I get to say Deborah a lot today because it's all of y'all. So, but with with that being said, we would just go ahead and say, yeah, I will go ahead and terminate it unilaterally. And this is what that looks like. Keep in mind, the top is if the client is terminating it, and the bottom is if the broker is terminating it. Again, the top would require the client's signature, and the bottom would require your signature. So just be aware of what that entails. Additionally, if we are going to terminate a lease, that's where things get a little bit more, I won't say complicated, but a little bit more goes to it. Because sometimes in the lease, there is not even a termination clause that will even apply. So if the termination in the lease states anything under 60 days, be very careful with this. This is a pet peeve of mine on those forms. You have to provide 60 days notice to the tenant. It says 60 days, but it's 60 days. You have to provide 60 days notice to the tenant. I don't care if you mutually agreed on a contract that it says 10, 15, 20, 30. The law says 60. So make sure you never do that. How much does the tenant have to give you as a landlord? Anybody? Do they have to give you 60 days?
No, they only have to give you 30.
Thank you. That is correct. So 60 days from the landlord, 30 from the tenant. So make sure that you are aware of that. And F925 would be that form in GAR, RE127 in RE, I'm sorry. And the CF49 for a commercial. I'm not going to touch a lot on commercial, but remember, if you're not a commercial agent, stay in your lane, refer it out, get it to somebody that knows how to do commercial. We are only to do what we are qualified to do as per the code of ethics if you're a realtor. Now, when you're terminating purchase and sale, that's where the fun begins, right? Unilateral or mutual. And it can be terminated for a contingency, such as a due diligence, finance, appraisal, but we can also do it for non-compliance, right? Or even title or default. But that's where it gets tricky, right? So we've got to be very careful in noting what those terminations involve. So if it's due diligence, and say your seller doesn't want to sign a unilateral termination or even a mutual termination at that point, well, just explain to them. They have every right to, right? Because it was a valid reason. Where it gets tricky is obviously when there's a default. So with that, if we're doing a unilateral or mutual with terminating the pre-SA, we could be very clear on the dates. This is why I get so upset when I see that a PSA doesn't have a binding agreement date on it. How do we know what those due diligence periods are if we aren't clear on the binding date, right? Let's make sure that you always, always have that clear binding date so that we have the clear due diligence. And make sure to understand due diligence starts. So day of binding is day 0, and then the next day is day 1. So if we have 3 days, today is day 0, tomorrow is day 1. Make sure you understand that. For some reason, that becomes tough for a lot of people. So I always like to explain the day of binding is day 0. And understand the difference between due diligence and right to inspect. Who can tell me the difference? Anyone? Take a stab at it.
What was your question?
What's the difference between due diligence and right to inspect?
Well, due diligence, they have the right to terminate during that period. Right to inspect, they have the right to request repairs.
But they could also terminate.
Oh, I didn't realize that.
Yeah, so the main difference is that the due diligence is for any reason. They woke up on the wrong side of the bed. They decided they didn't like the house after all. For whatever, it doesn't matter. The right to inspect, as you had stated, they have to request those repairs. So they've inspected, they've requested repairs, and it can only be based on that. It can't be that they woke up on the wrong side of the bed. That's the main difference. So just understanding that it's not an arbitrary termination, whereas due diligence technically is arbitrary. It can be for anything. So there's a little bit more to it, but that's the bottom line. But they can walk away with the right to repair. So with that, oops, I think I skipped one. I apologize. So with that, when you are doing a unilateral or a mutual, if we're doing mutual, that requires both parties, but I mean both brokers to sign. And it does require both parties, the seller and the buyer. Remember, brokers are not parties to the contract. So when I say parties, we're referring to only the buyer or the seller. Brokers are not parties to the contract, only buyer and seller. But it does terminate all obligations on all parties if we're doing it mutually. Kind of like we talked about with the buyer brokerage and the seller brokerage. It's a final settlement agreement, and it relieves any future liability. And you can negotiate the terms. I mean, we can say, okay, we're gonna mutually terminate, but you don't have to just walk away with 0. You could say we're gonna mutually terminate, but you're going to pay me for that photographer I used, or you're going to, well, this is a purchase and sale, sorry. You're gonna pay me for that inspection. You're gonna pay me for that appraisal. You can decide that. You guys can negotiate. This year, make it a point that this year becomes your year of negotiation. You have to become an expert negotiator this year and think outside the box. So that's part of, even in termination, that you still have your negotiating powers in place. Again, with the unilateral termination, it only requires one party. No broker needs to sign, and it does not terminate all obligations. So you want to always use the unilateral if it's a contingency deadline so that you're protecting that earnest money. So just make sure that you use unilateral in that sense, because we want to make sure that that earnest money is protected for that party. Now, GAR has both termination, like GAR has the termination and the disbursement. You know, I'm going to terminate the contract. The earnest money goes to this party all on one form. I actually kind of like the way that RE does it because they have it in 2 forms. But GAR has it all in one form, the top and the bottom. So if you're terminating a contract, you sign the top, you get the one person to sign the top, and the bottom must be signed by both in order to disperse. It must have both the buyer and the seller signature. But in order to disperse, if we don't have both, then we go into a 10-day situation or into an earnest money dispute. So that is where things get a little bit shaky, right? Anybody here? Hi, Ellie. Hi, Edie. Has anybody here ever been in a situation where they had to deal with a 10-day letter or a termination of a contract? Just raise your real or virtual hand. If you're on camera, real, virtual, if not. Okay, so a couple of, well, one. Okay, only one. I'm shocked. Okay. And so with that being said, were you on the buyer side or the seller side, Carla?
I've been on both.
Yeah, unfortunately.
It's a complicated, it's a cumbersome situation, where you have to not disperse, but generate 10-day letters, give time, because
Yeah.
that's what it's mandated by,
By law, by the
by
contract.
law. Yeah,
Exactly.
so.
And exactly. We're going to talk about that in just a moment, but yeah, it becomes a little bit tricky whether you're being on the seller side or the buyer side. So it's definitely something that we're going to look at. But once it's terminated, it's terminated. However, this is something I want y'all to be aware of. We created the form to reinstate, the F-290. We created that form in order to give you the ability to reinstate. So, for instance, you guys were at the point of amendment to address concerns. And you said, okay, here's the amendment to address concerns. You're representing the buyer. You call the seller's agent at 10 p.m. or at 10 a.m. because your ATAC is your due diligence period is over tonight at midnight, right? And you tell them at 10 a.m., hey, am I going to get that signed today? And they tell you, yeah, I'll get it signed tonight. And now it's like 10 p.m., right? And you haven't gotten anything back. Do you just trust that it's going to be signed? No, you need to terminate that contract in order to protect your buyer. So in that situation, even if I was told that the seller was going to agree to the repairs that I asked for, I'm going to go ahead and send a termination. I'll probably send an email along with it that says, hey, we didn't receive it back and I need to protect my buyer. So I went ahead and sent the termination. However, tomorrow we can reinstate if everyone's in agreement. That's what this form F-290 is so great for. So you would go ahead and protect your buyer, terminate that contract, explain to your buyer, you're not truly going to keep it terminated if everyone agrees tomorrow, but that way you can just reinstate it tomorrow with one form. Make sense? Everyone follow me on that? And that way we would reinstate it tomorrow with the condition that all those repairs are done. So that's how that would work. It's a great form to use for that scenario. But let's understand what earnest money is, what it has the potential to become. Because if you don't understand it, you might be putting your buyer or your seller in some situations. So let's understand the ramifications. It is not a deposit. It is not in the sense of option money. It is not option money. Who can tell me what the difference is between option money and earnest money? Putting on my Jeopardy music. Who can tell me what the difference is? What is option money? Okay. Well, option money is basically money you're going to offer the buyer is offering the seller in addition to everything else. So for instance, if I offered 500,000, my earnest money was 5,000, but I'm going to say I'm also going to give the seller 2,000 in option money. The buyer is going to directly give that money to the seller. It is not earnest money. It does not get touched by the broker. However, how it's going to be applied at closing is directed in the contract. So be aware of what that option money is. We don't see it a lot right now, but there was some option monies being given more during COVID. I know other states like North Carolina and South Carolina use it a lot more. So that is something that you may want to understand and look at if you ever need to, especially in a multiple offer situation, because it does become non-refundable. Here's a slide that I had made a while ago. You're welcome to screenshot any of this. But with that, because this is when the earnest money goes back. The buyer gets it back if A, it never went binding. Obviously, if they had given earnest money, if it said, it's already been provided, then they obviously get it back because it never went binding.
The highlighted route,
Just
then
cut
the
it off.
route guidance will start.
Oh, hang on a second. Let me mute some of y'all. They also would be if there was a failure of an unexpired contingency. For instance, due diligence, finance, etc. And of course, seller default. And of course, if there had been some specific rights, such as an ATAC that wasn't done, something like that, some repairs. But here is the issue. And it has changed. This is last year's forms, but it's similar. So the holder may disperse the earnest money upon a reasonable interpretation of the agreement. So I forget who it was. I think it was Carol that was talking, or Carla that was talking about the termination that she had to do. We send out, as a broker, I'm going to send out a 10-day letter. If I have a unilateral termination that said the buyer is terminating and they felt that it was during their due diligence period, but the seller refused to sign because the seller says, I want that earnest money. So then me as a broker am going to look at the contract and I'm going to have a reasonable interpretation of the agreement. Me, when I say me as a broker, let me rephrase that, me as the earnest money holder. So at that point, I'm going to do a reasonable interpretation of the contract, read all the timelines, see if it was during due diligence. Yeah, it was during due diligence. So the buyer is entitled to that money. And then I'm going to send that 10-day letter to all parties involved and state what reasons I give as to why that money goes back. At that point, there would be a time that the other party has the right to give any additional facts. And then I can either choose to change my opinion or choose to disperse the money. But it should be dispersed upon closing, written agreement, court order, or lack of enforceability. Those are the 4 reasons that it would be dispersed. Here again, this talks about the steps. We just talked about it. Basically, we're going to do the interpretation. We're going to look at any objections. If I modify it, then I do have to send a 10-day notice if I found some new facts that I wasn't aware of. Be aware, because I've had sellers get upset with me because I'll say I need the W-9, but we are entitled to request a W-9 if the amount is over $600, which it most of the time is. So that's, Uncle Sam requires that. Now, interpleading. If I can't make a reasonable interpretation, this is just too clouded, I can't figure it out, then I'm going to send it to interpleading. I've never had to do that myself, but here's the thing, the holder is entitled to all the costs and expenses. So if I have to send it to court, to an interpleader, then whoever loses is going to have to pay those expenses. So that is why you want to avoid interpleading as much as possible. I have talked to you guys probably till I'm blue in the face, and you probably are sick of hearing this for those of you that have been in my classes. But if it's an all cash deal and you decide to have the earnest money being held by the closing attorney, then the closing attorney cannot do that 10-day letter process that I just explained. It goes automatically to court, to interpleading. So be very aware of that. If you have an all cash deal, you do not want the attorney to be the earnest money holder, because that could be a situation that the only winner is going to be the attorney, right? So be very, very cautious. So cash deal, if your brokerage doesn't hold earnest money, then give it to the other agent's broker, as long as hopefully one of them holds money. Because if it goes to an attorney, you're not going to be happy if there's a dispute. Be very careful with that. Everybody clear on that part, right?
Yes.
Carla, you have a question?
Deborah, is the 511, does that specify that that's the position that the attorney takes? Or is that just something that they decide on their own? Because the 510, to my understanding, or 511, to my understanding, they adopt all duties of a broker.
Right.
As far of a holder, excuse me.
No, it's a great question. And here's the thing, Carla, if you look at the 510, this part right here that I have on the slide, this is from the 510. So the 511 is just an acknowledgement from the attorney. So the 511, by the way, should never be an exhibit in your contract. It's only the 510.
Correct, but the 511 is the agreement
That
of the
is
attorney that adopts the duties of
510.
holder.
Right, but it goes back to the 510.
510, okay.
And this is the 510. The only remedy available to the
Okay.
closing attorney to resolve the dispute is in a court, in an interplea that funds in a court of competent jurisdiction.
Okay.
So yeah, but great question. And that's where you have to be cautious because a lot of people don't realize it because this is in the 510. Now, keep in mind, RE forms does not have anything like this. So if you're going to use an RE form, it's a whole other story. But if you're going to do a cash close with a GAR form, be aware that this is the situation. I would not have an attorney hold it at that point. Now,
Deborah, it's Deborah Irwin this time.
yes.
Hi. Excuse me. So, if the broker can't come to a conclusion, whoever's holding the money and it's not an attorney can't come to a decision. And then, I mean, wouldn't it be going to court anyway? So what's the difference between that and the attorney holding it?
Great question. Well, the difference would be that if I, as a broker or earnest money holder, can very rarely can I not look at the contract and come up with a reason, right?
Right.
Because it's usually pretty clear. So I will be able to do that reasonable interpretation. I'm going to be looking at the timelines. I'm going to be looking at the signatures, all that. So I can 99.9% of the time come up with a reasonable interpretation. The difference is the closing attorney can't even do that. They're not even allowed to do any type of reasonable interpretation. We skip that step. So that's why it makes a big deal. Because if it was a clear cut, this goes back to the buyer. It still has to go to interpleading if it was a cash deal.
Well, that's interesting because I was multitasking when you asked earlier if anybody had that happen to them. And so, yes, I had that happen to me and the attorney was holding the money and he actually made the decision. It didn't go to court.
Well, he had an F510?
Yeah.
I don't know. I mean, it's clear here. I would have fought it if I was on the other side because it's very clear there. That's what it states. They're not supposed to.
Yeah, well, my client was on the other side, so that's the problem.
Oh, well, yeah. If your client was on the other side, I would have said, hey, we've got to take this to interpleading according to the contract. So, yeah, because it's very clear there. And it was an all cash deal. There was no loan.
In that case, let me think about that. Hold on just a second.
Because if there was a loan, he's allowed to do that.
No, then that's what I'm thinking back on. Hold on. No, you know what? You're right. I'm sorry. On that one, there was a loan. Yeah.
Okay. Yeah,
Yeah.
I was going to say, yeah, with a loan, they can do that. I'd be very surprised if an attorney did that.
Yeah, no. So, okay.
Yeah, if there's a loan, they can do the same thing I can do. But if there's no loan, they cannot.
I was off on that part. Sorry, multitasking.
Oh, no worries, no worries. So yeah, that's the thing. If it's a loan, if it, all day long, give it to the attorney if there's a loan. But no loan, no. No loan, you'd rather give it to the other agent. Now, what if there was no money given? That's a question that I'm asked all the time. Because all of a sudden, there was an NSF check or it wasn't paid, that type of thing. Then you have to give notice to that buyer that there was no money given. And a lot of times I see the listing agents kind of sit back and they'll ask the agent for the money. But, hey, do we have copies of the earnest money? But you want to make sure if today was the day that the money was supposed to be in and you're the listing agent, you call the earnest money holder. Don't just rely on that agent. You want to make sure that you call that earnest money holder and get proof that it was provided. Because if it was not provided by the end of that time, then you need to make sure that you tell that person that, if that was my situation, I'd be calling the attorney and I'd be like, listen, it was due today. So tomorrow I expect you to be sending a letter to cure, a 3-day letter to cure. So make sure that you do that, because I even dealt with that right before the call. Somebody's like, well, my seller's looking for the money. I'm like, okay, but there is no money provided. So if there was no earnest money provided and the time frame has gone and there was no letter to cure, you're going to have a hard time recouping that for your seller, and you're going to have a little conversation with your seller. I wouldn't be very happy if I was your seller at that point. So make sure that whether you're on the listing side or on the buyer side, that you confirm that that earnest money was provided by the time that it was given. But let's assume no money was provided. Then what next has to happen is that the notice must be given by the earnest money holder. So what I would do at that point is I would send a letter to cure. You don't automatically have a termination there. That's another misconception. People think, okay, they didn't give me the earnest money by today, so tomorrow I can put it back on the market or go with my backup. No, you now have to provide the 3-day to cure. So if after the 3 days it's not cured, then the seller can, within those 7 days, go ahead and terminate the contract. But here's the thing, seller decides, oh yeah, I'm going to do it. The agent doesn't stay on top of it. All of a sudden, day 8 comes along. You now have a binding, full enforceable contract with no earnest money. So be very careful. So these timelines become very, very important. Anybody ever been in that situation? No? Good. I prefer that. But be aware that you have to give that notice. But where I see the mistake a lot of times is I hear agents, and even my own agents call me all the time and say, hey, no money was given, so I'm just going to go with my backup tomorrow. No, it doesn't automatically terminate the contract. You have to give that that notice to cure. So just stay on top of the earnest money holder. Attorneys take a little longer sometimes to write that notice to cure. So you have to be on top of them, because the timeline of those 7 days doesn't happen until that notice to cure has been given. So be aware of that. So that's another really, really kind of not seen thing, but it happens all the time. So any questions on that? Okay.
Who is the burden of proof on the notification of the earnest money? Is it
Not
on the holder, or is it on the agent, or is it, who does the burden of proof lie on that notice?
Well, the notice is given by the earnest money holder. So, the burden of proof would be on the earnest money holder, basically, because basically you're going to call me and say, hey, did Odella or Lacey give me the earnest money? And I'll look, no, it's not here. And then say, well, it was due today. Please send a notice to cure. So tomorrow I would have to send a notice to cure.
Right. So whose responsibility is to police that? Is it that of the agent, or is it
Yeah.
that of the
Oh, yeah.
holder?
No, well, in that sense, if it's who it is to kind of make sure that happens, it would be you as an agent. So that's
what happens if the holder just relies on the agent to, is that something that there's consequences upon the holder for not?
Nope.
Okay.
Nope. Yes, good question though. But no, what you want to make sure you're doing, that's why I said, I don't care if you're on the listing side or the buyer side, you're making sure. Because otherwise, no, the holders have too many transactions to go through, right? Now, I can tell you, us as a brokerage, we do check those timelines. And if it was due today, then I'm going to be checking on it. But I can't say that that's the case in every brokerage or every attorney's office. So it really depends on the policies of your brokerage. But we as a brokerage do like to make sure, hey, it was due today. Where is it? So I would assume most brokers do that. I'm not so sure all the attorneys do that, because they're dealing with way more than we are. So your best bet is just to stay on top of it as an agent. And no, there's no consequences otherwise, other than you're going to end up with a contract with no earnest money. So that's where it's important. But great comment. Great. Thank you for, whoops, that's wrong. So this one, if there was no earnest money received, okay, a lot of people think, well, we never really went binding. But did you go binding? If you went binding and then you got to the point where the very following day after you went binding, the buyer decided to wake up on the wrong side of the bed and terminated the contract, you still have to address that earnest money because the earnest money was addressed in the contract. So now it has to be addressed on the termination. And please, guys, when you're writing a termination, whether it be in this scenario or another, here it says buyer to retain earnest money not yet submitted. I don't like ambiguity. So if this was the case, I would actually say Shayna Rivers to retain earnest money not yet submitted. You know, I would actually use the name. I would probably go as far as saying Shayna Rivers, comma, buyer to retain earnest money. More is more in this scenario because you want to be very, very clear on who is the person that's going to be retaining that money. But if it wasn't submitted, this is a correct verbiage to use right here. Buyer to retain earnest money not yet submitted. So again, here you would need both signatures. I get a lot of complaints where the other party says, yeah, but no money was given. Why do I have to sign it? Understand, in a scenario like this, where the buyer to retain earnest money not yet submitted, and the buyer signs it, but the seller refuses to sign it, I still have to write a 10-day letter. I don't want to write a 10-day letter for something like that. So please understand and explain that. Use that towards your education to explain or educating your client. We still need to sign it. It doesn't affect you. There's no money involved. So just make sure that we do it. So with that, I'm going to go ahead and ask you guys to give me takeaways, comments. Here's my information if anyone needs it. And let me know what you think. Let's open it up. I want to hear from you guys.
Deborah, I have, not about this, and let me know if this is premature before anybody else asks other questions, but I wanted to talk a little bit more about, this new,
Elephant?
settlement being taken care of. Yeah, I just have a couple more questions about that. As far as, like you mentioned, FMLS, isn't, part of this. And so I'm just wondering if, we can still put in the listing that sellers are offering commission for the buyer's agent.
Okay, so